withdrawal.
Serial number?
For withdraw, for memo for withdrawal.
Memo.
To be listed.
18 ରଖିବେ ଆଉ କଣ?
Recording in progress.
ଆପଣ ବୋଧେ ମୁଭ୍ କରୁଛନ୍ତି 17ଟା ଛୁଟି ପାଇଁ ନା କଣ? 16ଟା ଛୁଟି ଡେ ଫଲୋଇଂ ଏଥର ନାହିଁ, ଶିବରାତ୍ରି ପାଇଁ ଏଥର ନାହିଁ, ବିକଜ
ମେ ବି
210 ଦିନ ଆପଣ ମାନେ ମୁଭ୍ କଲେଣି ବୋଧେ ନା କଣ ସେଟା?
ଏପର୍ଯ୍ୟନ୍ତ ଜଣା ପଡୁନି।
ହଁ ବା ସେ ଆପଣ ସେପଟେ ଟିକେ ଦେଖିବେ ନା, ଏମିତି ସବୁ ମୁଭମେଣ୍ଟ ଗୁଡା ଠିକ ଠାକ କରିବେ। ଠିକ ଅଛି, ତାହେଲେ ସେଇ 17କୁ ରଖିଥାନ୍ତି। 17 ଛୋଟ।
Your Lordship, item number 27, praying for an adjournment.
Page. We'll go page wise, no difficulty.
1 to 9.
Are kindly taken it after 2 weeks.
कितने कहले? Item कितने?
1.
1 पे बेस्ट होतन। अरे 1 since I'm always don't mention 1. ठीक है जी, पोस्टिंग कर दियो, कहले तो डेट कर देबे।
16 की फुल कमेंशन 16 की। Page to 10 to 15.
Millards, item 11, Millard. Kindly be taken on next week. I am not feeling well, Millard.
Next week not possible. Truncated, so केबे करंतु
फुल कमेंशन 2 की।
2-3 ହେଲା
Obliged, Millard.
जल्दी डाकंतु कोन आपण एते
Page 3, 16 to 19. Page 4, 20 to 27.
Your Lordship, item 27,
47 you want adjournment?
adjournment.
Okay,
फुल कमेंशन page 3.
yes.
Page 5, 20 to 30.
Yes.
Item 1.
At what they call it?
Item 2.
My lord. Please, Your Lord.
Yes, please.
My lord, in this case, petitioner challenges the judgment dated 14/5/2005 passed by the London Judge Family Court,
Yes.
Parampur,
Yes.
awarding maintenance of rupees 10,000 per month
So please from the date
from
from when, sir?
from the date of filing of the application
Application, huh?
under section 125(1) CRPC.
Yes, sir. What is the
Is
date
the
of,
date of
sir, what is the date the amount becomes due?
It will be around more than 3 lakh rupees.
Sir. Secure the amount.
My
For
lord,
issuance of notice, you have to secure the amount, because I have discussed and exasperated now. I have now become exasperated. Actually, every day, 3-4 cases are argued like Kesavananda Bharati from the morning to 1 hour, 2 hour. No question of law, nothing. It is an interim order. It's interim maintenance.
my lord,
And the order, the decrees are violated with impunity. And this court is invited to help you in violating the order, violating the law laid down by the Supreme Court.
my lord, the case.
So have you checked Rajneesh versus Neha? Read it. What is the latest? So now I'll be happy to, because I'm also concerned when you are saying that there is a lot of difficulty. But what is the law, sir? What is the law on the point?
My lord,
And what evidence you have adduced, what the court has considered, what is the scope of? So you straight away come with the
my lord, the case has been falsely constituted.
excellent argument, sir. Excellent argument, but false case. So who will say? The magistrate, the district family court, or the appellate court?
And it has been
If you listen, sir, it will not register. I accept yours, sir. Why have you proved that it is false?
no, my lord.
Then
But
then can it be your exception?
in the court below, he has filed his counter.
Not counter, sir. This is a trial. This is not a writ application. Look
Yes,
at the statistics. Look at the evidence.
He has.
So I cannot pass an order that's counter filed and it is said that it's a false case. All these things. Sir, in claim of a 125 CRPC maintenance, what is false?
My lord, the marriage is not valid marriage.
So,
It's
so,
consummate.
so the magistrate can declare 125.
But
Since it is not a valid marriage.
it's not taken into consideration.
So which provision is
Statement
your?
of the petitioner.
You will not listen, that's why you will not read yourself, neither you will listen somebody who has tried to read that list. I continue to be a student of law. So here we are not exchanging ideas and speeches, though we are live. Is it that you will go on a discourse which are completely not relevant to the topic? Which provision in the 125 CRPC?
My lord, section
Marriage. Marriage has to be considered and proved by the party.
My lord, I submit subsection 4 of 124 CRPC.
Yes, yes.
No wife shall be entitled to receive an allowance
Hmm.
for the maintenance of interim maintenance
Hmm.
expenses of proceeding as the case may be from her husband under this section
So your written statement, sir?
if
Look at
she-
your, I have read it, I have little bit faster because already we have so many benches. So look at your written statement, what you have stated regarding the 125(4).
content with 4
Now
and
you look at your written statement, what you have stated and what is your evidence on that?
no, I'm not having the written
If
statement.
you do not, that's the problem, sir. This argument before coming to the High Court, as a counsel, you should have looked at it. It can't be a bluff. Please appreciate.
No, my lord.
My conclusions cannot be based on bluffs.
It is not based on bluffs and
Sir, kindly show that, sir. Kindly show so that you must understand what you are saying.
my lord.
You have not. You said it is recorded that you have not seen the written statement. So can I base my conclusion? Can it be based on a bluff without seeing looking at the written statement? 125(4) has been proved. Yes.
Let the
No
notice,
case, sir. No case.
let the notice go.
No, sir. Illegal notices should not be issued. That I'll record. I'll reject your contention.
My lord.
I cannot improve also because it is everything is transparent and recorded.
Yes, my lord.
So that is how I am again and again with some patience I am tolerating this.
My lord. The fact is that, my lord, the
Sir, your fact of speech, it's not a matter of a speech on a platform. It's a question of trial and law, evidence, materials.
petitioner has a
125, sir, kindly look. Sir, how many times I have to tell you, take the code through your written statement.
I am not having the written statement.
So I will record that, sir. I will record that. That's it.
Then allow me some time.
No. After filing the petition, how can I cannot do that.
That is
Sir,
recorded.
there is last one of the honorable judges.
My lord, his statement.
Preliminary, semi-final, quarter-final, semi-final, then final, the cases cannot be adjudicated.
My lord, kindly appreciate.
You kindly appreciate the limitations of the court. That if the written statement is not filed, the court will allow you to time to after disposal.
His
Sir,
statement.
which provision I can allow you? Give further chance after hearing? Which provision in CRPC or RPFM, wherever?
My lord, his statement has been recorded by the magistrate.
Sir, your written statement I am asking you, where you have taken this plea and what is the evidence?
That is not right now.
You will not secure the decree or you will secure the decree? So looking at me, I can't secure. You yourself, you cannot secure. You should have asked this question to the person who is playing with law. Sir, you cannot be a medium for playing with law. Please appreciate that.
No.
You cannot because you are a much higher pedestal. You are officer of the court.
No.
You have to be you have to elevate to talk. Straightforward questions have to be asked. These questions. I am not requesting you for this information. Only assisting you.
Right.
These are not necessary. I can simply dictate the order.
Right.
This you should have asked your client. That this is not a matter of jokes.
My lord, I will withdraw the petition and
No. You have written instruction from the client.
he has not supplied the.
So I will record that also. Yesterday I have been doing that.
So I want to withdraw and file it.
Very well, I'll pass orders. No difficult.
File again
No.
with legal.
Sir, no preliminary and then quarter final. Round robin league, this is not, litigation is not that, sir. After you come to court, the matter is adjudicated, then you have a second innings. At least have you taken that ground that in written statement in so and so, this evidence is there. So this can't be that casual for violating court's order, judgment, decrees. And the High Court will be party to that. To issue notice. Which is the law on this revision? That would be you have to educate me that whether the High Court can look into the again and the reappraisal of evidence, allow you to file further application. So these things cannot be casual. This is somebody's life.
Revision.
Your inability to pay, fair enough. You concede there that you are a performer pauper. It was you pleaded being a pauper before the trial court. Then,
He has vehemently argued the matter and
sir, vehement argument doesn't help without material.
but with
That is what I have been
material,
telling
he
you.
has also
Sir, where is your?
adduced the evidence before the trial court.
Yes. Look at exhibit.
the marriage-
What is exhibit 1?
Marriage is not valid
Look
marriage
at-
and
Sir, if you don't read and listen, then still you are struggling. Look at page 36, exhibit 1. What is exhibit 1? Why you are muted, sir? This is a courtroom interaction. What you are reading, how I will know. What is exhibit 1?
exhibit 1 marriage invitation card.
Here, microphone is on. Exhibit 2, 2 to 6.
2 to 6 marriage photographs of both the parties.
Exhibit 3.
Joint photograph of both the parties.
What is the evidence disproving that?
No, marriage.
How you cross-examine?
No. My lord, marriage has been solemnized.
Sir, can it be?
It has not been.
Mr. Mohanty, can it be a matter of speech and discussion? I'm asking you how you have disproved exhibit 1, 2 to 6, then exhibit 3. It's a very simple question for a lawyer of your stature and experience to answer. How you have disproved it? What is the evidence rendered by you? Sir, you can't read, you can't have the retrial.
My lord,
The Supreme Court has said very
allow some
clearly.
time. Allow some time.
Sir, time will not improve, sir.
I will.
So I will also record that. After answering all these things, you are seeking time. That I will also record, no difficulty. Yes. You kindly take your seat. I have to dictate the order. Mr. Samarendra Mohanty for the petitioner. Yes, please. What you are saying?
Kindly allow 2 weeks.
No, sir. You must understand that we are spending time in adjudication.
Actually, item 2, your Mr. Kader Mohammed.
Kader Mohammed.
Sorry. Sir, Mr. Kader Mohammed, sorry.
Item 2. my lord.
I'm sorry. I
My lord, delay is also there.
correct. It will be dismissed both on merits and delay. This saga cannot continue, sir. This saga of non-compliance of decrees, the courts and the lawyers running after the persons. Sir, you are not supposed to, sir. You are at a much higher level, sir. If they don't listen to you, let them face the consequence. It's a correct brief. So I was thinking that how the pages are matching. Because in physics, this paperless, you kindly take your seat. Mr. Kader Mohammed for the petitioner. Mr. Opposite party blank. The petitioner, husband in the marriage, has filed a revision application challenging the judgment dated 14/5/2025 passed by the Learned Judge, Family Court, Berhampur, You kindly take your seat. I'll dictate. I have to take some time. I cannot do it instantly. Yes, you take your. You did not stand up. Asked by the learned judge. The said judgment. By the said judgment, the petition under section 125 into bracket 1 of CRPC, then into bracket, since repealed and substituted by perimeteria provision contained in BNSS, 2023, bracket closed. Check to be allowed. Stop. The Lorded Judge Family Court granted payment of monthly maintenance at the rate of rupees 2,000 per month, 10,000 per month from the date of filing of application, that is 8/2/2022. Hello. 8/2/2022. Though the amount paid for was rupees 20,000 per month. Litigation expenses of rupees 2,000 was directed to be paid instead of rupees 15,000 as paid for. Your instruction is very clear. Nothing has been paid.
Well, nothing has been paid.
Okay. Okay. The petitioner has opted to remain in default of the direction of payment of rupees 10,000 per month, which is due to be paid from the date of filing of the application. That is 8/2/2022. The total amount till 8/2/2026 comes to 10,000 into 48 कर देंगे 10,80,000. In Rajneesh versus Neha, INS paragraph it has been laid down by the Honorable Apex Court that the amount directed to be paid in proceedings under 125 CRPC is in the nature of money decree.
And sorry to,
Yes, please.
it would be 38 months.
4 ବର୍ଷ ହଉଛି
ନାଇଁ
38 ମାସ ନାଇଁ ମୋ ଆପଣଙ୍କର ଆରିଥମେଟିକ କଣ ହେଲା?
8/2/22 ରୁ
ହଁ 8/2/26 4 ବର୍ଷ ହଉଛି
from till the date of judgment.
ହଁ 4 ବର୍ଷ ହେଲେ 48
No, till the date of judgment, 38 months.
କଣ ବୁଝି ପାରୁନାହାନ୍ତି ବୋଧେ?
No, I understand.
ଆଉ ତାହେଲେ କଣ 48 କଣ 38 କହୁଛନ୍ତି?
The award has been,
ଟୋଟାଲ ଆମାଉଣ୍ଟ ଡ୍ୟୁ ହଉଛି ଫ୍ରମ ଦ କେତେ ହେଲାଣି?
award has been passed till the date of judgment.
ନାଇଁ ମୋ
Yes, ma'am.
ଏଟା କଣ ଏକ୍ଜିକ୍ୟୁସନ ହେଇଛି?
Execution has been filed.
ହଁ ତାପରେ
That has been posted.
ହଁ ସେଟା ମୁଁ କଣ ମାନେ I will also look like an idiot.
No,
That was taking
sorry.
of the matter. No. ଆରେ
Sorry.
no, I was saying sorry.
I don't-
ଆପଣ ମୁଁ ହିସାବ କରିବି 4 ବର୍ଷକୁ 38 ମାସ କଣ ଆପଣ କହୁଛନ୍ତି?
Sorry.
ମୁଁ ବୁଝିପାରୁନି ସରି କାହିଁ କହୁଛନ୍ତି ସାର୍? ଡୋଣ୍ଟ ବି apologetic. You are holding a brief. Why you are wearing them coat and gown and band? You are not nothing personal. So that is how I can confidently say. ମୁଁ 4 ବର୍ଷକୁ 38 ମାସ କେମିତି କରିବି ଆପଣ କଣ କହୁଛନ୍ତି ମୁଁ ବୁଝିପାରୁନି.
Oh, I had the idea would be counted up to the date of judgment. That is,
No. Who provision? The day the appellate court takes up the matter, he has to the day today I have to consider the facts.
my,
କଣ ଆପଣ କହୁଛନ୍ତି?
Always.
जजमेंट को दिन कौन कहते जो दिन रिट मैंने फाइल कले
No, the lower court.
लोअर कोर्ट जजमेंट जो दिन है से दिन हम ड्यू और पूरा पढ़ू ना पारा पेज 35 देखो पेज 35 ऑर्डरिंग पोर्शन यही कथार समय नष्ट कले केमती हम पढ़ु फिफ्थ लाइन केते 8-2-22
8-2-22.
8-2-22 ରୁ 8-2-26
8-2-26 48.
इट हैज टू बी अरे सेमती केमती अरिथमेटिक एरर हवा कथा नुह दैट पॉसिबली बट आपण कहबे 38 मु कहबे 48 मिस्टर महांती कहबे 58 मिस्टर लेंका कहबे 60 ई कोन दैट कैन नॉट बी इट हैज टू बी प्लेन एंड सिंपल द डे द मैटर इज बीइंग कंसीडर्ड व्हाट इज ऑर्डर इज आल्सो दैट मु आपण को केते टका डायरेक्शन दे परिबी पेमेंट करंतु बोली 10 लाख टका कैन से
No.
then so you must understand the logic. I cannot at best ask you that why you have not paid because you are refusing to secure the decree. So my order is that how much I can expect you to pay? I can expect you to pay 48 months only. March 48. 38 मास केमती कोचन भी मु बुझी पानु कोन in the nature of a money decree. After the Lord Council has made his submissions for fresh admission, he was asked whether the petitioner is willing or has secured the amount due as a money decree for issuance of notice. In response, the Lord Council submits that as per his instructions, the petitioner is not willing to pay. He disputes the marriage. In response thereto, the Lord Council was asked whether within whether 125 CRPC, whether for considering 125 CRPC, what is the scope of going into the aspect of disputed marriage or not. The Lord Council refers to section 125(4), which is reproduced hearing. Upon such submission being made, the Lord Council was asked to show before this court the written statement of the petitioners disputing the marriage and the evidence adduced before the learned Judge Family Court. In response, it is submitted that the written statement filed before the learned trial court is not available. Accordingly, has not been provided to the learned counsel. Accordingly, he cannot reflect upon the written statement to answer the query whether the marriage was disputed before the learned court. The said aspect has been dealt with by the learned Judge Family Court in paragraph 10 of the judgment, which is reproduced herein. From the judgment, it can be seen that the learned trial court has relied on the following evidence. Page 36 रे अछि देखिबे witnesses examined हो नै की exhibits nil looking at the taking note of the exhibits marked before the learned Judge Family Court. Exhibit 1, exhibits 2, then TO2 TO2, then space 2/6 1 टा लिखिबे marriage invitation card, marriage photograph, exhibit 3 joint photograph. लिख ले. Look, taking note of it. लिख लेता हूँ. The learned counsel was requested that how the petitioner had disproved or had made any effort to disprove the said exhibits. In response, the learned counsel for the petitioner has no immediate answer. From the judgment, it is apparent that no material was brought before the learned trial court to disprove the marriage. The statements of the PW1 and PW2 substantiated the claim for maintenance. The statements of the OPW1, OPW2 produced by the petitioner before the learned trial court did not inure to his benefit to deny the claim. The learned trial court has relied on the exhibit 4 and 4/1. Those are copies of the payslips of the petitioner for the month of October 2023 and November 2023, downloaded from the official website into bracket net. To arrive at the source of income of the petitioner, who was the opposite party. The learned counsel for the petitioner submits that though the petitioner is not willing to secure the decree, secure the amount awarded by the learned trial court for issuance of notice, but notice can be issued. The judgment rendered by the Honorable Supreme Court in Samima Faruqi, at para 20 of SEC print, the scope of interference in revision has been delineated. ଆପଣ କଣ କହୁଛନ୍ତି କି ଯେ କାଢି ଦିଅନ୍ତୁ ବୋଲି କାଳେ ମୁଁ ଦେଖିବି ବୋଲି ମୋର ତ ମନେ ଅଛି. Anyway, the scope of interference is delineated. Applying the said parameters as laid down by the Honorable Apex Court, this court cannot interfere in the judgment, there being no material. Further, the unwillingness of the petitioner to honor the decree without any reasonable ground or cause, and also the unwillingness to secure the decree. Decree is only amount awarded before the appellate court. Further, further comes in the way of the matter being entertained. In view of the order that is being, the judgment that is being rendered, it does not affect the rights of the opposite party in any manner for which notices are not issued. The petition is dismissed, being devoid of any merit. Copy of this judgment shall be forwarded to the so and so to be kept in the records of so and so. Which fortune? Yes.
Item 3.
This is the second contempt, my lord.
So what I should do? I should dispose it up and wait for the third contempt, or I should do anything else?
Annex or one,
Hey, wow, sir, what is the what the court will do, sir? You should also assist.
non-compliant.
Like I got third contempt kariba na nahi apon kon
I'll take.
se mana korchen third contempt.
I'll take
Second
it.
contempt disposal se mana. ठीक ଅଛି.
The order was for disposal of representation. I'll take it.
Mr. Vasudev Barik for the petitioner. Mr. Dear Lenka IGA for the opposite party alleged contempt now. The petitioner, by filing the application, alleges non-compliance of the order dated 101.02.2022 passed by the coordinate bench.
Yes, sir.
By the coordinate.
By the coordinate bench, disposing of WPC number 2984 of 2022. Stop. Take your seat. I'll take some time. Stop. Full stop. Full stop. It is further alleged. No, it is not further alleged. It is further stated that the petitioner filed CONTC number 2006 of 2022, alleging non-compliance of the said order dated 101.02.2022, which was disposed of by order dated 19.01.2024. Say कौन है लास्ट कितने दिन टाइम देले
1 month.
granting
What's that?
disposed of granting further 1 month time to the opposite parties to comply with the order dated 01.02.2022. Date वाले देखी देले बेटर ना भूल वाली. The learned AG appearing for the opposite party upon advance copy served submits that he will obtain instruction regarding compliance of the order dated 01.02.2022 and seeks accommodation to obtain instruction. Accordingly, the matter shall be listed in the Quebec, Mr. Lenka. Quebec, कितने दिन समय पूरा?
3 weeks.
4 weeks date कर दिया तो. In the week commencing 30/3/2026.
Item 4.
Item 4 में कांटेक्ट टेक्नो मंडे में
नहीं adjournment. अब दरकार नेक्स्ट वीक ना आउट वीक ले हबो.
नो मैं मंडे आसो काहे ना
ताले एटा मंडे तो नुहो मंडे होनी एटा 17 को जो 17 कर दियो.
अबले
Item 5.
I'm pleased, my lord.
Mr. Acharya, Mr. Manoranjan Acharya for the petitioner.
My lord.
Yes, please.
The application of the petitioner for maintenance has been rejected, my lord.
Ground, sir?
Ground on the ground of voluntary dissolution of the petitioner to the family of the opposite party, and on the ground second ground is that is living in adultery. On those two grounds,
So why you are pursuing this?
my lord,
Is there a section 13 application pending?
no, not pending. One application was filed that was not contested by the
Who has filed
by my client, my petitioner.
Who filed the application? An application under which section? Who filed?
But the petitioner had filed, the petitioner wife has filed an application for divorce.
Under which
But,
section?
under 13B, my lord, 13A. My lord, may kindly see
13(9), 13(1)(1).
page 22, my lord, kindly see.
Page 22 is not the provision. 13
I mean, page 22 of the judgment he has dealt, my lord.
अरे मो सेक्शन टा पचार दी जजमेंट हैज देन.
13A रे फाइल करथिला बोल actually.
13 ए अछि. कोन तो
यहाँ लेखा है मु आगे कहछि.
आपण बय जानछन दी.
आज्ञा
बय जानछन दी किछ.
ना आनी ने
आउरी बोल.
it is lecture say it is evident from exhibit C
नहीं सर,
that
ठीक है,
the
ठीक है।
petitioner has
से
instituted.
मुझे क्या कहते हैं, समझदार को इशारा काफी होता है। जहाँ भी होटल 13 तो कौन 13 13 13B 13B अच्छी सर।
That time I repeating.
नहीं शुणु तापर कौन है ताकू पढ़ो सियाड़े याडे
Set up
शुणु टिके बी पेशेंट आपण काई व्यस्त होचोदी मु व्यस्त होवा कथा 13(1) रे जो आपण पिटिशन फाइल कले वाइफ फाइल कले सेडा कौन हैला सेडा कॉन्टेस्ट कले नि हस्बैंड
contest नहीं wife contest कला
वाइफ प्रोसिक्यूट कले नि
wife भी contest कले नहीं ताको wife फाइल करथिले wife contest कले
सेडा कॉन्टेस्ट कला जानी इंग्रजी भूल होला ये फाइल करनी ताकि से एबे प्रोसिक्यूट कले नि
prosecute कले
अदर साइड कॉन्टेस्ट कले
contest कले
आपण जो कॉन्टेस्ट पर
ये prosecute कले further.
डिसमिसल फॉर डिफॉल्ट हो गला
हाँ
ये जो सीरियस एलिगेशन रे आपण जदी व्हाई यू आर परसुइंग दिस
two documents.
व्हाट इज द स्कोप ऑफ इंटरफेरेंस इन रिवीजन जदी आपण को मटेरियल प्रोड्यूस होला 125 फोर मटेरियल प्रोड्यूस हेछि 125 वाज आर्ग्यूड टुडे इन फैक्ट बट मटेरियल किछि नाही आपण को केस रे 125 फोर मटेरियल प्रोड्यूस होला लिविंग इन एडल्टरी करेक्ट सो सेतरे आपण को तापर आपण को रिटन एविडेंस कोन थिला how the court on a trial court arrived at a conclusion because it is a question of fact.
Question of fact.
Have you read the judgment of rendered by Honorable Justice Deepak Mishra? Very eloquently written judgment.
Good.
So what is the scope? How this court will give a finding on that?
Only one point I'm.
Sir, point कौन मिलियो सर point बहुत अच्छी.
आज्ञा.
समस्त पाखरे point अच्छी. मु एविडेंस ऊपर टे चेष्टा करछि कन्फाइन करिया पे so that आम डिस्कशन रे किछि मीनिंग रहबो. ଆପଣଙ୍କର ଯୋଉ ସେ କୋର୍ଟ ଫାଇଣ୍ଡିଂ ଦେଲେ लिविंग इन एडल्टरी क्रुएलिटी वॉलंटरी डिजर्शन ए तीनटारे आपनकर हाउ यू हैव रिपोर्टेड दैट बिफोर द ट्रायल कोर्ट जोटा कि आई कैन गो इनटू दैट नाउ किछि देइथिले ना सेमती वर्तमान मु कोन करिवि ताले
आज्ञा
देखो एडजमेंट नियंतु वाइफ्स पिटिशन में बुझुची बट आपनकर हाउ आई विल इंटरफियर गिव ए फाइंडिंग सी इज नॉट लिविंग इन एडल्टरी
I will take time.
देयर इज नो
Yes, fine.
I will take that what
I am taking time, but
नहीं टाइम में आपण एविडेंस देउनांती बामर आज समय बहुत गुडे बेंच अछि समय कम अछि
नहीं से कथा जे
आपणकर कर्तव्य वर्तमान एज ए लॉयर सीधा पेज 35 को जिबे
आज्ञा
देखिबे एविडेंस कोन थिला
आज्ञा
स्टेट रे एड्रेस करिवे सो दैट दिस कोर्ट हैज समथिंग टू डू अब जे आलोचना करिया तो बहुत कथा बहुत पॉइंट आलोचना हे परियो कोन एविडेंस दिला आपण
एविडेंस रिपोर्ट
सर से मिस्टर कादर गोटे भल जिंस कहले कहले से रिटेन स्टेटमेंट देखि नांती आ जदी सेटा आपण जदी कहबे मु देखिनि कि जानि हम कोन करियो ता जे चांस ही नहीं
I
have a chance also
I will elaborate most आज्ञा it by bit सब पड़ची I have a very bad case
no से कथा नो
but
never sir
only two things
sir there are completely decided all cases are good मुझे कथा बुझी पर नथिले हाउ जो कहंती जे ग्रेट लॉयर्स मेक केस आउट ऑफ नथिंग यू नेवर फाइंड ए केस आउट ऑफ नथिंग बट द स्ट्रांगेस्ट पॉइंट दे आर्ग्यू गोटे पॉइंट जदी स्ट्रांग अछि सेमिति आपण डिफिडेंट
लॉन ट्रायल को
देखि चंदी कि एविडेंस ताको एग्जामिन करंतु देन बेस्ट पॉइंट यू आर्ग्यू
Learned court will not relied on exhibit A and exhibit B, which are the photocopies of those original documents.
सेटा जदी सर कहिले सेटा आपण ट्रायल कोर्ट नबाक पड़ियो आपण को सेटा बर्तमान मो कर परिबेनी बर्तमान प्रॉब्लम होची सुप्रीम कोर्ट सेज क्लियर नॉन एप्लीकेशन ऑफ माइंड ऑफ द हाई कोर्ट व्हेन हाई कोर्ट गिव्स ए कंक्लूजन व्हिच इज पॉसिबल I cannot give it आपन कथा एक्सेप्ट करले पॉसिबल आई विल से दैट फोटोकॉपी सो नॉट एंटर आपन सेटा को डिस्प्यूट करिवे ट्रायल कोर्ट रे ट्रायल कोर्ट सेटा को आपन डिस्प्यूट ग्रहण करिवे तला यू हैव ए वेरी गुड केस
सेटा भी हेनी
ओ हेनी ताले आपन
एग्जीक्यूटिव आपन 15 दिन आई प्रेफर 2 weeks time also 2 weeks time
and thanks for your time at least we've had a
ultimately even
let us see आपण जदी चैलेंज करचंती फोटोकॉपी बोली ट्रायल कोर्ट ताकू कॉल ग्रहण करि नांती देन इज ए वेरी गुड केस बट आपण सेम बोली करचंती तो जाने ताले आपण मनोरंजन आते जो इलेक्शन बोल The petitioner wife in the marriage.
I prefer
has challenged-
time, my lord.
Correct. Time sir, teachers.
देखिए तो
But since I am spending time in discussing, so I have record that. Yes. Only. The judgment dated 09.12.2025 passed by the Lord Judge Family Court Noyagad in CRL.M.P.NO.127 of 2023. Kindly take your seat, Mr. Acharya. I'll take some time. You will not stand up.
आगे मत छिड़ा ले कंफर्टेबल काना मुझे तो स्कूल ले भी पढ़ुतली एडुकेटेड तो थी मु मत छिड़ा कि मु सब स्कूल ले धर के डेस्क ऊपर पढ़ुतली
Our school, I was the fortunate not to stand up. No.
सार कोन पढ़ुतली मते मु सुनिले सेटा को
Very strict school रे आपण जे करनो थियो ताको दिन सारा छेड़ा करिवे.
सेटा एक कथा द्वितीय कथा
दिन सारा माडा दियंतु. That those are the things. आपण भाबे तो मोर फर्स्ट पीरियड रे सरला भूल करथिली सेकंड पीरियड थर्ड पीरियड फोर्थ पीरियड फिफ्थ पीरियड
नहीं
you never know. Stop. By the said judgment, the learned court has dismissed the petition filed by the petitioner wife in the marriage under section 125 of CRPC, claiming monthly maintenance of rupees 20,000 per month. The learned counsel for the petitioner was had at some length. He has accommodation to address further. As short for list in the week commencing 16
आगे
16 March 2026 week रे आसु.
Item 6.
Matt Visuals.
Yes, please. You are Mr. Rautre.
Yes, my lord.
Mr. Saroj Kumar Rautre for the petitioner.
My lord,
Yes,
here,
please.
here, my lord, petitioner wants to transfer his 24 MAT case number 81/24 from civil judge senior division High Court to Cuttack, my lord. The last occasion, my lord, on dated
से जोटा आपनकर ये प्रिजाइडिंग ऑफिसर नाहंती.
my lord, since September, month of
सेटा
September,
टिके डिफिकल्टी अछि. I understand that.
my lord.
But that can be a ground to transfer a petition because the reason being आपन केबे फाइल करले.
I filed
24 रे.
again.
So 24 पूर्व petition pending अछि. That is another problem. Now suppose I pass a order in the judicial side.
My lord.
It has a binding precedence in the administrative side also. On that ground.
I understood.
But what you are saying is correct.
My lord,
Even I have some access at Athawad of R, so that is how I met a very senior person who said this to me. About the code bond kar dele. This is what he said. And this process of resignation and acceptance and little bit we take time in accepting a resignation because we think that a person should not resign. It's a job worth having. I mean, a job
now also, my lord, all the
but
cases are
24 पूर्व जो तो बहुत matter pending अछि, we start transferring on that ground and becomes a difficult proposition. Adjournment नहीं था तो ठीक है.
no dates also in lower court, no
Correct,
dates.
correct. I fully agree with you. Yes. The learned counsel for the petitioner refers to the order
Yes.
dated.
Yeah, Your Lordship.
Yes.
Your Lordship, just have a look to subsection 2 proviso of 447.
Right. Sir.
Here is a case that I am reading. Provided that no application shall lie to the High Court for transferring a case from one criminal court to another criminal court in the same session division unless an application for such transfer has been made to the sessions judge and rejected by him.
It is a mad case. Sir.
Yeah, it's a criminal case.
No.
TRPC.
It is a matrimonial dispute.
C, sir.
Yes.
TRPC.
TRPC.
सेठी आपनकर सिविल जज सीनियर डिवीजन जोडा हियरिंग करछन माने अकिन टू फैमिली कोर्ट जोठी फैमिली कोर्ट नाही तांकर कॉन्करेंट जुरिसडिक्शन अछि सिविल जज सीनियर डिवीजन ना बट व्हाट इज सेइंग इज करेक्ट
समान प्रिंसिपल
समान प्रिंसिपल आपण कहउछन
24
माने आगो सेशंस कोर्ट को जिवे
जबकि
सीपीसी रे कोन पैरामीटर प्रोविजन
सेक्शन 24 पे ट्रांसफर
अपन सर पढिला एटा सीपीसी ना सीआरपीसी सर सीआरपीसी पढुछन
24 also same provision is there.
अच्छा
Same provision is there.
बट प्रॉब्लम होची सी जो ग्राउंड नौचंती से ग्राउंड रे डिसीजन करिवे
Because family court judge is a senior judge.
डिस्ट्रिक्ट जज सेटा करि परिबेनी सेटा हाई कोर्ट ही करिवे 227 226 सब उभय होई परिबो 227 बेसी so सेटा that is a issue
But administrative
but
judge,
for educating me at least that provision is there but that sort of order that the session judge can never pass that due to vacancy I am transferring the matter
फैमिली जज ही गले डिस्ट्रिक्ट प्रिंसिपल कोर्ट रो भी क्षमता रही
in fact family judges are many times are principal judges they are posted as a family judge but they are senior to the principal judge
24 कहता जदि प्रिंसिपल डिस्ट्रिक्ट कोर्ट सिविल कोर्ट रो जुरिसडिक्शन भीतर रही
24 of CPC
हां
section 24
या आज्ञा है ताहले से आगो दिबे प्रिंसिपल डिस्ट्रिक्ट कोर्ट को पाखु से जदि मना करिवे ताला आपण
आज्ञा in judicial side but see कहले जे सेठी आज्ञा प्रिजाइडिंग अफसर नांते आपण का दउ नांते सेठी
कोर्ट है ना आपण को छोड़ा की कर पे आपण को कोर्ट छोड़
आज्ञा थैंक यू The learned counsel for the petitioner refers to the order dated 21/1/2026. He reiterates his submission that due to the presiding officer not being there at civil judge into bracket senior division, comma 8th. The proceeding has been stalled. The matter is adjourned to be taken up in the week commencing not in
Madam Sir, you are arising out of a PDS matter. License was cancelled earlier. Approached the Honorable High Court. High Court, since it is an appellable order,
IDM.
Appeal was filed, collector. Then in appeal,
Yes.
stay was granted,
Yes.
but no
License could not be restored.
I filed an interim application. My prayer is to consider that application. Now, the matter is posted for hearing.
Yes.
So a question of consideration of interim application can be taken at the final hearing.
Yes.
But what he has done, this order,
Rejected.
no. He fixed the case to 24,
21.
25 to 26.
Yes.
Now he has advanced it, sending me a notice. So my limited grievance before my lord would be on 25 to 26. He may finally hear the matter, giving me opportunity and conclude the, if not, then my interim application be considered.
Mr. Lenka, it is a very fair submission, very whatever.
This order you got seen, I look at it.
You
अगर अच्छी से copy.
नहीं तंका पाखे नहीं.
तांको दियो. But you can hear what is ever. कहा कहता है जे आपण जेनु को hearing the date has been posted for hearing.
Yes.
Let it be taken up. Upon why it is preponed and the matter.
That is my predicament.
So I mean the state is not prejudiced or nor he is prejudiced. But why it is to be preponed? At whose instance?
25 थिला 11 को कर देले
11/1 11/2
2 मो सेठी टाइम देले गोटे तारीख
एटा कोन इंस्ट्रक्शन देबे ना डिस्पोज ऑफ कर देबे
Your Lordship,
न जदी इंस्ट्रक्शन देबे त 17 को आनिबी
no, your Lordship can. Why they have people? Your Lordship can.
आपण जदी चाहू मते लागुनी देयर इज एनी दैट कैन बी एनी रीजन सपोज आपण अपील करी कि अदर साइड कहले कि प्रीपोन करनो एटा किमिति हबो एटा तो तांका अपील मोन हिच कोइ परिबिनी आई कांट से फॉर श्योर व्हाट हैज हैपेंड एग्जैक्टली
Page 25 is clear, my lord.
25 of writ petition
Yes.
yes एकुश 26
Yes.
हाँ तापरे हला केबे केबे कहउचंती 25/2/26
25/2/24. तो ये
25/2
दीटा अपील अछि गोटे 1 गोटे 2 दीटा स्वयंसेवक संघ से जो स्वयंसेवक संघ तो नहे
स्वयं सहायक गोष्ठी
आज्ञा मोर कहवा कथा मु आसीथिले मो प्रेयर देखंतु मो इंटरिम एप्लीकेशन विचार करंतु आपण जेतु स्टे करचंती मो लाइसेंस ता ऑपरेट करियो दियो
अच्छा आरे मैटरटा कोन प्रीपोन हो जेछि
आज्ञा ए देछि ऑर्डर ता दीटा
एटा काहे कि हेछि माने बिकॉज़ द अदर मैटर हैज बीन पोस्टेड टू
same.
दीटा एक समान
Same date. 21.
ସେମ୍ 21 ହେଇଛି 21 ପରେ କଣ ହେଲା
21 ଏକ୍ସାଇଜ ଅର୍ଡରଟା ଦେଇଛି ପୁରା
21 25/2 କୁ
ରଖିଲେ ତାପରେ ସେ
ରଖିଲେ, ତାପରେ
ହଁ ସେଇ 25
ସେଟା ବି 25 ବି ରଖନ୍ତୁ ତାକୁ ପ୍ରିପୋନ କାଇଁ କରୁଛନ୍ତି ତ ଆପଣ 17 ଆଣିବେ ନା ଡିସ୍ପୋଜ ଅଫ୍ କରିଦେବି ଆପଣ ନହେଲେ ଯଦି ଦିଟାରେ କନଫ୍ୟୁଜନ ଆପଣଙ୍କର ହଉଛି ଆଇ ଡୋଣ୍ଟ ୱାଣ୍ଟ ଟୁ ସର୍ଟକଟ୍ ୟୁର ରେସ୍ପନ୍ସ
I will take
ବଟ୍ ଡେଫିନେଟଲି ଆମେ 17 ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ ବିକଜ ଇଟ୍ ଇଜ ଓନଲି ସିମ୍ପଲି ହି ସେଇଂ ଦ୍ୟାଟ୍ ମତେ କାହିଁକି ଆପଣ ପ୍ରିପୋନ କରୁଛନ୍ତି ସୋ ଇଭେନ୍ ହି ଇଜ ନଟ୍ ଆର୍ଗୁଇଂ ଏନିଥିଙ୍ଗ ଅନ୍ ମେରିଟ୍
ଆଜ୍ଞା on 17th you know.
yes
till then no judgment ବି ଅର୍ଡର ବି ପାସ୍ 11 ରେ ସେ କରିଥିଲେ ମୁଁ ପାର୍ଟିସିପେଟ କରିନି ଅର୍ଡର ଯଦି କରିଦେବେ
ଠିକ ଅଛି ଦ୍ୟାଟ୍ ଇଜ ଅଲସୋ ଫେୟାର ସେ ନ ଶୁଣି ଅର୍ଡର କଣଟା କରିବେ ଯଦି ଆପଣ ଫେଭର କରିବାକୁ ଚାହୁଁଥିବେ ନ ଶୁଣି କରିବେ ସୋ ଦ୍ୟାଟ୍ ଆପଣ ଆସିବେ ଗୋଟେ ରିଟ୍ ଫାଇଲ କରିବେ ମିଷ୍ଟର ଲେଖା କହିବେ ଆଇ ହାଭ୍ ନଥିଙ୍ଗ ଟୁ ସେ ସୋ ରିଟ୍ ଇଜ ଆଲାଉଡ୍ ଫର ଦ ପିଟିସନର ଆପଣଙ୍କର ପତିତ ପାବନ ଯିଏ ମା ଶାରଳା ବୋଥ ଆପଣ ଆପିୟର କରୁଛନ୍ତି
ଆଜ୍ଞା
ମାନେ ସେ କଣ କମ୍ପିଟିଂ କ୍ଲେମ୍ ନା ନାଇଁ ଅଲଗା ଅଲଗା
ନାଇଁ ନାଇଁ ଅଲଗା ସମାନ ୟାର ଯାହା କ୍ଲେମ୍ ତାଙ୍କର ସେଇଆ କ୍ଲେମ୍ ଦି ଜଣଙ୍କର ସମାନ ଲାଇସେନ୍ସ କ୍ୟାନ୍ସଲ
ସମାନ ଲାଇସେନ୍ସ ଅଲଗା ଜାଗା ପାଇଁ yes Mr. Siddharth Mishra for the petitioner, Mr. D.N. Lenka, IGA for the
ସେ ଦିଟା ମୁଁ ଦେଇଦିଅ ଜେରକ୍ସ କରି ଦେଇଦେଉଛି ତମକୁ
opposite party
ଦେଇଦେଉଛି
ସେଇଟା ଟିକେ ଆପଣ ଟିକେ ଜେରକ୍ସ କରି ତାଙ୍କୁ ଦେବେ ଠିକ ଅଛି ଗୋଟେ ଦିଟା କପି କରିବେ ଗୋଟେ ଲେଙ୍କା ସାର୍ ଗୋଟେ ଦେଇଦେବେ ତାଙ୍କର ଲେଖିଲେ ଲେଖିଲେ ଅପୋଜିଟ୍ ପାର୍ଟି ସବୁ ଅପୋଜିଟ୍ ପାର୍ଟି Mr. Lenka, you are appearing for the PDO also?
BDS
All opposite party. ମୁଁ ମତେ ଦେଇପାରିବି
ମୁଁ ଅପିଲ ଏକଟାରେ ଆଣିଛି
Correct. No issue.
ଯୋଉଟା ସେ ଯାହା ନାଁ ସାରଳା
এটা গেল রিট কোড ডাইরেকশন দিয়ে দিলে এক্সপিডিশন শেয়ারিং পেল
ରିଟ୍ କୋର୍ଟ ଡାଇରେକ୍ସନ ଦେଇଥିଲେ ଅପିଲ ଫାଇଲ
ଅପିଲ ଫାଇଲ କରିବା ପାଇଁ ଦେଇଥିଲେ
ଲିଭ୍ ଦେଇଥିଲେ ଗ୍ରାଣ୍ଟେଡ
ଡେଟ୍ କିଛି କହିନାହାନ୍ତି ତ
ମେରିଟରେ କିଛି କହିନା ଅର୍ଡରଟା ମୁଁ ଆନେକ୍ସ କରିଛି ଆପଣଙ୍କ ରିପୋଜିସନ
ଆଜ୍ଞା ବୋଲେ ହାପିନେସ୍ ଲେଖିଲେ The learned counsel for the petitioner submits that the petitioner has approached this court after filing the appeal. You take your seat, Mr. Mishra. I'll take 2-3 minutes. After filing the appeal before the appropriate authority under the PDS control order, challenging removal. Upon remove challenging removal of the petitioner organization as a PDS dealer. PDS dealer. Okay. During pendency of the appeal, the matter was posted to be taken up for hearing on 25/2/2026 by order dated 21/1/2026 of the collector Kendrapada. It is submitted that thereafter, by communication dated 3/2/2026, the collector has intimated the present petitioner for taking up the matter at 11/2/2026 3 p.m. It is submitted that such preponement of the date prejudices the petitioner. So, otherwise also there is no cause for preponement inasmuch as both the parties to the appeal before the collector are not prejudiced if the matter is taken up on 11/2/2026. No, sorry, taken up on 25/2/2026 as per the order passed earlier. Consider the very limited nature of grievance raised before this court. The learned AGA is learned AGA who has been served with copy of the said order of preponement and the order of posting. Order of posting dated 21/2026, posting to 25/2/2026, and order of preponement dated 3/2/26 shall obtain instruction so that the matter can be finally disposed of, directing the authority to stick to the original scheduled date of 25/2/2026. ଗୋଟେ ମେମୋରେ ଫାଇଲ କରିଦିଅନ୍ତୁ ଜେରକ୍ସ କଲା ପରେ ଗୋଟେ ମେମୋ ଦେବେ the matter shall be listed for fresh admission on 17/2/2026. Rest of the matter, since there is another
Till then, no final order.
till the next till 17/2/2026, the learned AGS shall intimate the authority not to proceed in any manner with hearing of the matter. And
mention one thing was
please,
item number 16.
16.
Yes.
16. Yes.
The noting is that notice is not sufficient because the notice is gone, it is written answers.
Sir, let us see because now I am interdicted by time. So I should not take up any matter. If you want any date, you will adjust it.
17th.
Sir, next week, can you leave next week? Because already you have posted some matters for 2-3 days and other social, functions are there. So then, upon 2 days, next week, chhad diyo.
Rest of the matter,
All matters will be in the list. No, nothing is, yes, you can take the date or he will be giving the date.
Matter, item 8, matter, let it be taken. Item 8, let it be taken today.
Sir, today I think at 2 p.m. there is another bench.
So it will be listed to 17
I
matter.
cannot say that bench will proceed.
One request, matter, let it be listed on 17 matter. 20th date is there, matter. The matter court below is going on violating the statutory.
17 ରେ ସାର୍ ଯୋଉଟା କହୁଛନ୍ତି
Sir, violating the violating the mandatory provisions of law matter. This is
Please don't